Don't hurt minors. They're very sensitive.
Will Senate please come to order? We'll observe a moment of silence in lieu of a devotional. Thank you. Are there any announcements? Seeing none, we have House bills for reference. H727, an act relating to sustainable data center deployment. Introduced by Representative Sibilia of Dover, it passed the House on March 21st of 2026. Listen to the first reading of the bill.
H727, an act relating to sustainable data center deployment.
Now you've heard the first reading of the bill. It's referred to the Committee on Finance. H935, an act relating to emergency management, introduced by the Committee on Government Operations and Military Affairs. It passed the House on March 31st of 2026. Listen to the first reading of the bill.
H935, an act relating to emergency management.
Now you've heard the first reading of the bill. It's referred to the Committee on Government Operations. H938, an act relating to establishing the Vermont Homelessness Response Continuum, introduced by the Committee on Human Services. It passed the House on March 31st of 2026. Listen to the first reading of the bill.
H938, an act relating to establishing the Vermont Homelessness Response Continuum.
Now you've heard the bill's first reading. It's referred to the Committee on Health and Welfare. Orders of the day. We have H694 for third reading. Are there any amendments prior to third reading? Listen to the third reading of the bill.
H694, an act relating to approval of amendments to the Charter of the Town of Bennington concerning the town manager.
The question is, shall the bill pass in concurrence? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and we have passed H694. We have on the calendar for action H84, introduced on January 24th of 2025. It was referred to the Committee on Health and Welfare, which reports it's considered the bill and recommends that it ought to pass in concurrence. Listen to the second reading of the bill.
H84, an act relating to allowing telehealth appointments to be recorded with patient and provider consent.
Recognize the senator from Chittenden, Senator Gulick, for the report of the Committee on Health and Welfare.
Mr. President, this is the rare bill that came to our committee and left in the same exact form as it came to us, so that was exciting. Health and Welfare wanted to be the committee with the first bill after crossover, but my neighbor to the left of me, Senator Zuhoski, scampered up the steps faster than I did, so she gets number one and we get number two, which is okay. This is H84. It is an act relating to allowing telehealth appointments to be recorded with patient and provider consent. Right now, healthcare services that are delivered through telemedicine cannot be recorded. This is a problem because it means that healthcare providers must manually take notes whilst also listening to their patients, assessing their health, and trying to communicate with them. This practice has resulted in hours of extra administrative burden for healthcare providers, and it has caused high levels of burnout amongst our practitioners. According to the Vermont Medical Society, 57% of practitioners say the EHR, the electronic health record, is a top source of burnout. While this bill what this bill does is it allows healthcare providers to, and I'll go through the process with you, to record a telemedicine consultation with the patient's consent, and then go through then the telemedicine would send the recording off to create a summary. And then the healthcare practitioner would read that summary and go through it and make sure it's accurate, and then share that recording with the patient. So that is how it works. The tools that are used in this process are HIPAA regulated. They're often an app on a phone, but they could be on a computer or on a different device. And this process is also helpful because currently, if you're a patient and you're in a telehealth visit, you're actually not supposed to be recording it yourself. So this will also allow patients to legally record their own visits. If you look at the bill, it's pretty straightforward, I believe. If you look at the bill, you will see that in section 1, there is an amendment. It amends 18 BSA chapter 9361. This is the chapter that is titled Healthcare Providers Delivering Healthcare Services Through Telemedicine or by Store and Forward Means. What store and forward is, according to the Center for Connected Health Policy, it is the transmission of a member's medical information, for example, an image, a video, a laboratory or medical record, or another document or source of information from an originating site to the healthcare provider at a distant location, a distant site. So this is commonly used for teledermatology, for example, for skin conditions, teleradiology, X-rays, CT scans, and teleophthalmology, for example, retinal images. It would add to this chapter one line, and you can see it on the bill that you were handed, unless both the patient and the provider consent to the recording. So thus far, it has not been allowed. There was a prohibition on this, but we're adding that language to allow. It would then amend section 2, chapter 9362, which is healthcare providers delivering healthcare services by audio only telephone. And it would do the same thing. It would just add that one line unless both the patient and the provider consent to the recording. The effective date is on passage. We voted it out of committee 5-0-0. The witnesses were Ledge Council, the sponsor of the bill, Daisy Berbecco, Amy Johnson of Vermont Care Partners, Devin Green of the Vermont Association of Hospitals and Health Systems, Ann Morris, who's the Associate Dean of Primary Care at the Larner College of Medicine at the University of Vermont, and Jessa Barter of the Vermont Medical Society. With that 5-0-0 vote out of Health and Welfare, we ask that the Senate concur. Thank you, Mr. President.
Are you ready for the question? Senator from Chittenden Central.
Thank you. Might I inquire of the presenter of the bill?
The presenter's interrogated.
Is the usage of the recording limited to note-taking, or could it be used for training purposes or other purposes?
Yes, it could be used for other purposes.
Okay, and how long can the recordings be kept and stored?
So that was a question that I asked in committee, and I believe, my understanding is that it's not in statute, but there is a best practice. And it is typically for I believe it's 3 months after a patient's demise, death, or 10 years after the patient has seen a practitioner.
So that's the best practice for how long they should be held on to?
Yes.
Okay. Was there any testimony taken as to whether or not these recordings would be subpoenaable at any court cases?
There was no testimony taken on that.
I thank the presenter.
Are you ready for the question? The question is, shall the bill be read a third time? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you've ordered third reading of H 84. We have on the calendar for action H540, introduced on January 6th of 2026. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that it ought to pass in concurrence. Listen to the second reading of the bill.
H540, an act relating to the recommendations of the Post-Adjudication Reparative Program Working Group.
Recognize the senator from Chittenden Central, Senator Vihovsky, for the report of the Committee on Judiciary.
Thank you, Mr. President. While I was the first one to get a bill to the Secretary's office, I'm noticing it wasn't on the calendar first. But H540 is also a fairly straightforward bill, and also a bill that has not been changed in the Senate and is exactly the same as it was when it arrived to us in Senate Judiciary. I'm going to give you a little bit of background on where H540 came from. In 2024, we worked on H645, which became Act 180. And part of that bill was tasked with the larger task of the bill was to create a uniform community-based restorative justice program for people across Vermont to really create geographic justice and geographically just access to restorative justice services. One of the aspects of Act 180 was standing up the Post-Adjudication Reparative Program Working Group. So this is a narrow subset of people who enter into restorative justice after they have been adjudicated. That working group was comprised of the Commissioner of the Department of Corrections or designee, the Chief Superior Court Judge or designee, and 5 representatives that were geographically diverse from community justice centers across the state of Vermont. The working group was tasked to define the program and the scope of the program, determine the offenses that would presumptively qualify for the program, establish eligibility for the program, define uniform procedures for the program, assess capacity, and explore ways to achieve financial stability. They were also working in consultation with the Attorney General's Office, the Department of State's Attorneys and Sheriffs, the Defender General's Office, and the Vermont Center for Crime Victim Services. So what H540 does is take some of those recommendations and put them into law. In Section 1, it is largely a technical change. It takes the language out of this sort of header section and moves it into another section that further defines. So it doesn't change anything, it just moves it around in the chapter. Section 2 eliminates the language for restorative justice to be used in child support cases. What we heard, well, we didn't hear it, but what the task force determined is that they'd never seen restorative justice used in instances of child support, and it really actually didn't make sense to use this program in that way. And so it simply crosses out that language of restorative justice applying to child support. And then in Section 3, it allows the court to require participation provided that restorative justice is an allowable avenue, which is actually already the law. It is just, again, there's a lot of moving and shifting in this bill. And this next aspect is also already the law, but you'll see language that allows restorative justice to be used without a probation sentence if the person doesn't successfully complete it and they aren't on probation, they are required to come back to court for resentencing. Again, this is already the law. And then the big change in here, one of the biggest things this actually does is it adds in factors for the courts to consider when they're considering restorative justice. Those factors are whether or not there is an agreement for the referral between the parties, the views of any victims, the impact of the offense on the community, the person's willingness to participate in restorative justice, and if there are any orders of protection. And then, of course, anything else the court wishes to consider. But it lays out that those things should surely be considered. The other thing that this bill does is it tasks the court administrator with creating a standardized referral form to be used in all of the courts in the state of Vermont. And it nudges the Supreme Court by saying that they can adopt procedural rules. Of course, the Supreme Court can adopt procedural rules without us telling them to, and we can't tell them to, but by putting in that they may, it's hopeful that we'll make a little nudge that it might be helpful if they did. And that's really all this bill does. Restorative justice has shown to be a very effective tool in accountability and the reduction in crime in our communities. And this is a small next step in the process of ensuring that all of the victims of crime in Vermont and all of the people who have done harm have access to those services. And then the effective date of this bill is the last subsection, which is, it will be effective on July 1st, 2026. Your vote in committee was 5-0-0, and we ask for the chamber's support.
The question is, shall the bill be read a third time? Are you ready for the question? If so, all in favor, say aye. Aye. All opposed, nay. The ayes have it, and you've ordered third reading of H 540. That completes the orders of the day. Senator from Chittenden.
Thank you, Mr. President. Pending announcements, I move that the Senate stand in adjournment until 11:30 a.m., Friday, April 3rd, 2026.
Are there any announcements? Senator from Washington.
Thanks, Mr. President. Appropriations to meet at 1:30.
Senator from Wyndham.
Thank you, Mr. President. Institutions will meet at 1:30.
Senator from Rutland.
Government operations will meet at 2.
Senator from Washington.
Thank you, Mr. President. Senate Finance will meet at 1:30.
Senator from Bennington.
President, 1:30.
Are there any further announcements? Seeing none, the senator from Chittenden Central has moved that the Senate stand in adjournment until 11:30 a.m., Friday, April 3rd of 2026. Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. Ayes have it, and we'll stand in adjournment until 11:30 a.m., Friday, April 3rd, 2026.